I found a state that nearly rivals California in LGBTQIA plus protections, safe spaces, oasis. I'm not sure which is the right term to use, but uh, Massachusetts is one of the most LGBTQIA plus supportive states in the country. Did you know that in 2004, it became the first U.S. state to grant marriage licenses to same-sex couples after the decision in Goodrich versus Department of Public Health, and the sixth jurisdiction worldwide after Netherlands, Belgium, Ontario, British Columbia, and Quebec? Let's talk about history. In October 1636, Reverend John Cotton submitted a legal code for Massachusetts Bay, which included the death penalty as a crime for sodomy, among other things. The code was not adopted. In November 1636, Plymouth listed sodomy as an offense punishable by death and quoted verbatim from Leviticus 20:13, which says, if a man lies with a male as lying with as woman, they both committed an abomination. They certainly will die. Their blood is upon them. The first trial for same-sex indecency between two men was in 1636 in Plymouth County. In 1641, Nathaniel Ward's code prohibiting sodomy was enacted. Now, Nathaniel Ward was a Puritan clergyman. He wrote for the colony of Massachusetts the Body of Liberties, a legal code which was adopted by the General Court of the Massachusetts Bay Company in December 1641. This was the first code of laws established in New England. In 1642, a Plymouth court charged Edward Mitchell and Edward Preston, as well as Elizabeth Johnson, with lewd and sodomitical, that's not a word, practices, but were whipped rather than executed. Sarah White Norman and Mary Hammond were charged with lewd behavior upon a bed. This was in 1649. They may be the only conviction for lesbianism in American history. In 1695, a state law was passed which prohibited men or women from cross-dressing. In 1697, a terminological update defined sodomy as detestable and abominable and contrary to the very light of nature. The Massachusetts Constitution of 1780 included a provision making sodomy a crime based on the Buggery Act of 1533 in the United Kingdom. In the mid, 1800s, I believe, Rebecca and Mary West of Chilmark took on the names William and Luther West and began living as men. In 1805, the death penalty for sodomy was removed, with the punishment changing to 1 year of solitary confinement and 10 years of hard labor. In 1835, it was revised again to eliminate solitary confinement as punishment, but increasing the sentence for sodomy to 20 years of hard labor. The Massachusetts legislature enacted a law in 1887 which prohibited unnatural and lascivious acts and aimed at oral. In the case Commonwealth versus Dill, the Massachusetts Supreme Judicial Court stated that the indictment that a defendant committed a certain unnatural and lascivious act was sufficient. In 1915, the Massachusetts legislature passed a law which prohibited using any saloon, cafe, or restaurant for the purpose of immoral solicitation or immoral bargaining. In 1918, it revised the 1887 law, lowering the penalty of those convicted from 3 years to 2.5 years. They were targeting the LGBTQIA+. During 2 weeks in May and June 1920, an ad hoc disciplinary tribunal headed of 5 administrators at Harvard University and headed by acting Dean Chester Noyes, Chester Noyes Greenough. They conducted more than 20 interviews behind closed doors and took action against 8 students, a recent graduate, and an assistant professor for charges of homosexual activity. They were expelled or had their association with the university severed. 2 of the students were later readmitted. It was not revealed until 2002. Massachusetts statutes from 1939 to 1945 required notice to police, data about any person convicted of sodomy, about to be released from prison, and filling out mental health reports on those arrested for sodomy before bail. In the case of Jaquith versus Commonwealth in 1954, the court stated that the existing sodomy statute was constitutional. 1948, the Boston Licensing Board banned female impersonators from performing on stage. 1952, selectmen of Provincetown, Massachusetts, enacted laws that banned drag shows and forbade restaurants and bars from becoming habitual gathering places for homosexuals of either sex. But the laws were ineffective at preventing this. 1972, a proposed criminal code for Massachusetts was published, which would have repealed crimes against nature and unnatural and lascivious act laws, but the code was never enacted. Massachusetts, though, did decriminalize sodomy in 1974 through a court ruling. According to the Massachusetts Supreme Judicial Court decision in Commonwealth versus Balthazar, the court determined that the statute which prohibited any unnatural and lascivious act with another person did not apply to private consensual adult conduct. This ruling came before the U.S. Supreme Court's decision in Lawrence versus Texas, 2003, which struck down all anti-sodomy laws nationwide. In the cases of Commonwealth versus Scagalotti and Commonwealth versus Ferguson, 1977 and 1981 respectively, the Massachusetts Supreme Judicial Court overturned convictions for an unnatural and lascivious act. The court in 1980, in Commonwealth versus Safranca, ruled against police actions which attempted to entrap gay men. 1992, the police raided a private home in Boston where police officers saw 160 men engaging in an evening of mutual pleasure, resulting in a police raid in which people were arrested on charges of obscenity and operating a house of ill fame.